Hello, everyone, and welcome to an episode of the Dairy Signal, where we bring you topics that are very timely and pertinent to your daily operation, regardless if you can implement it right away, today's business, or if it's something to consider down the line, either down the week or further into the year. So sit back, tune in, and if you're listening live, I strongly encourage you to ask questions. The beauty of the Dairy Signal is that we are bringing the experts to you, either at your fingertips, at your phone, whatever device you choose to listen in. If you are listening live, please ask your questions and engage. On that same note or same vein, if you are listening to the recording, by all means, reach out. We want to make sure that you get connected to these resources because they are for you to utilize. The Dairy Signal is made possible by our partners, our sponsors that help make not only the Dairy Signal possible, but also a lot of the educational content that you see us put on throughout the entire year. So again, special call out and thank you to our national partners who help make this possible. Thank you guys. Without further ado, because I think we have a fun, very timely topic. I mean, yes, it's kind of ignoring the weather. We're thinking some spring thoughts or hopefully long-term planning kind of considerations here. We have Kelly Wilfert with us with the Farm Law Outreach Specialist with the UW-Madison team, really kind of diving in as we think about farm building and livestock leases and negotiations. Like what steps, tools do we need to think about either in the immediate now or in the long-term situation. So without further ado, Kelly, thank you for joining us today. I had the chance to kind of preview and dialogue with you behind the scenes, but again, very timely topic. I feel like it's always a timely topic. Without further ado, I'll hand it off to you.
Well, thanks so much, Cassie. I'm really excited to be able to talk about farm building and facility leases today. Like you said, this is sort of always a timely topic, no matter what time of the year it is. Those folks who might be leasing farmland or farm buildings are almost always thinking about how is this going to interact with the landlord, especially if that landlord might be a neighbor or someone who doesn't have farm background. So in my role with the university, I do a lot of work on farm leasing generally. And a lot of times we stop at that farmland question because that's a lot to take in and of itself. But we know that for so many of our dairy producers, buildings and those livestock facility leases are really that next step and a big part of how they're managing moving on to that next generation or getting started in the dairy industry. So we have a lot to cover today. So I am going to dive right in. Whenever folks see my name with that JD behind it or Farm Law Outreach Specialist, they usually jump to the right conclusion, which is I am an attorney. That means I also always give this disclaimer that today's presentation is going to be for educational purposes only. I'm an attorney, but I'm not your attorney. We'll try to cover some of the general legal information and education, but you should definitely consult with your own attorney for legal advice on each of your specific situations. So as we dive in, today we're going to talk about a couple of areas. We'll kick off with really focusing on the legal sides of things. What are those basic requirements for enforceable leases and some of those management considerations and needs that you might want to negotiate in? Snow removal, anyone? If you're here in Wisconsin, that may have been a question over the last few days if you're leasing a facility, and lots of other things too. We'll also talk a little bit about managing disputes and terminating a lease, because sometimes we find that that relationship has run its course and we're moving in a different direction. We'll spend a little bit of time on negotiating a rental rate and some of the resources that are out there. I will say I'm a lawyer, not an economist, so we'll rely pretty heavily on the folks that are doing that work to provide some resources for you. All right, let's dive in. What do you think? Perfect. So the first place we're going to go is talking about creating a valid lease. And spoiler alert, although I'm an attorney, I'm going to acknowledge to all of you that verbal leases can be valid. Here in Wisconsin, the only things that are actually required to have a binding, legally enforceable lease are a beginning and end date, a rental rate, a description of the property, and the agreement of both parties. So you'll notice I didn't say a writing. I didn't say signatures. It's actually a pretty bare minimum requirement that we have to meet in order to have an enforceable lease. And that's why it's not uncommon across our state and across many states to have so many handshake agreements in agriculture. Keep in mind that different states may have different rules, but these are pretty general contract considerations that tell us we probably can have an enforceable verbal lease without having that written component. So I often find people sort of scratching their head and saying, well, why would I want that then? Crossing their arms and saying, no way, I'm not going through the headache. Why would you want or need a written lease? Especially if that verbal lease is sort of good enough. Well, it's good enough to a point. A big topic and a big risk for Wisconsin dairy producers and for dairy producers across the country is what's called our statute of frauds. This is a state law that almost every state has that says if you have a lease agreement for real estate that's going to be longer than 1 year, it has to be in writing to be enforceable. So, for example, Cassie, if I decide that I'm going to rent a heifer barn from you, and I'd like to rent it for the next 3 years, we might shake hands and agree on that. But if you decide that next year you actually need that facility back, you could terminate the lease. And I don't have the ability to enforce that full 3 year term because it wasn't in writing. So anytime we're going longer than 1 year, we've got to get it in writing. Otherwise, that other party could terminate us at, I won't say whenever they want, but at the end of each year. We'll talk a little bit more about that. A couple other reasons why you might want a written lease, though, are really for just that clarity and enforceability of the agreement. So, sticking with the idea that I'm going to rent a heifer barn from you, we have a lot of things we need to talk about, Cassie. Are there limits on how many animals I can put in that? Are there specific ways that I'm allowed to get to that building? Are you comfortable with me driving all over your property? Or are there certain access routes? Are you going to have access to that facility as well? Can you put animals in it? Who's paying for utilities? How are we calculating that? There's a whole host of topics that we're going to want to talk about before we actually move forward working together. Sometimes we think we've talked about it, and maybe we have, but we might remember that conversation differently. So I'm going to stick with the snow example today. I might say, well, Cassie, I'm just renting the heifer building, but you've still got a freestall barn and you've got another heifer building and you've got some calf hutches. And so my assumption is you're going to make sure all that snow gets cleaned out, that I can get to that facility when I need to, right? But you might be thinking, Kelly, I've got enough to deal with. That's your problem. You're leasing it. You figure out how to clean that snow out and get to it. Now, certainly with a record snowfall like this, at least up in northeastern Wisconsin, where I'm from, those expectations might vary as well, depending on, did we get 2 inches of snow or 2 feet? Are we talking about structural issues with the roof and how much snow is on top, and who's responsible for making that decision and paying for whatever labor or supplies we need to get some of that snow removed? If we haven't had the conversation, we don't know for sure. When we start putting things in writing, it becomes a little bit more clear. I might say to you, Cassie, I am going to pay utilities for the heifer barn, but how are we going to calculate it? And you and I might work together to figure out if there's a separate meter or if there's a way that we can estimate what that cost is. But we've talked about it before and we've tried to write it down, which means we're essentially having the argument up front while our relationship is still strong versus trying to have that relationship when things are going wrong.
So then, on that same vein, how fluid or flexible are these leases? Like, say you thought you were very thorough, you included a lot of these things, but maybe a few others came up that you want to now include to make sure we don't have muddy water going further. Can you amend a lease mid-year, or do you have to wait for a term period to conclude?
Nope, you can amend that lease at any point in time. Both parties typically do have to agree. And a lot of leases that we see come through are going to have a provision that specifically says both folks need to sign in order to have an amendment, but you can do that at any point in time. So, maybe you are leading up to, and I'm going to keep picking on this weather event. Mother Nature really handed me a great example here. Maybe we see this situation coming, and I'm going to give you a call and say, hey, Cassie, it looks like we're going to get a couple feet of snow. And I know what happened a couple years ago in different parts of the state. I'm concerned about the structural integrity of the building. I'm worried about how much snow the roof can support. Are you going to take care of that, or am I? Now, this becomes even more interesting, right? Because let's say that I'm going to be responsible for getting that snow removed. But you, as the owner, are typically responsible for structural repairs. Well, now we're sort of at odds with each other, right? If I
Mhm.
don't remove that snow, but it's my decision as to whether I'm going to do it or not, but your building collapses and you then have to repair it, whose fault is it? Well, now we're in a fight, right? Now we're
Mhm.
looking at potential litigation, arbitration, mediation, trying to figure out basically whose fault was it. Um, we're never going to solve everything, right? There are always going to be some unexpected situations that pop up. But the more that we can try to nail down what are those common areas of disagreement, the better off we're going to be. We'll dive into that a little bit later on. I actually am going to share a sample lease with our listeners and our viewers. And we can talk through what are some of those really common terms to talk about, and what are the oddball ones like snow removal that are probably more of a Wisconsin or Minnesota problem than our producers who might be down in Arizona or Georgia or Florida. The other topic that I want to talk a little bit on when we talk about wanting a written lease, though, is farm succession.
Mhm.
So, unfortunately, I have not yet met anyone who can guarantee that they are going to be able to run their farm forever. That means we always are thinking about what happens when the farm changes hands, whether that's to an unrelated party or to a next generation. Leases are a strong document for ensuring that both sides of the agreement know how that next generation is going to interact. So think of it this way. Cassie, I'm renting this heifer barn from you. And unfortunately, the proverbial bus drives by and takes you out, and you're no longer with us.
Oh,
I
watch
still
out for
want to
that
rent
bus
the heifer
syndrome.
barn. I know that darn bus.
Yeah.
But I still want to rent that heifer barn. I am
Mhm.
not looking to renegotiate with your significant other or your family. We had terms agreed. If it's in writing and we signed it, that's a lot easier to prove. And it's, certainly from the landlord side, as they're grieving the loss of that person, it's one less thing to figure out. It's already been negotiated and laid out for them. And the same thing goes if you're on the tenant side, if you're the farmer renting it. Um, Having an idea of how the relationship actually interacts and works is a lot more straightforward than battling grief and trying to figure it out at the same time.
So I think
So
I have a more specific question. So in these leases, is it usually two entities or like two specific people or parties listed?
it
Does
can
it?
be either one. So it really is going to depend on how the land is owned. And
Mhm.
we'll talk a little bit. I'll give you a few examples of how we figure out, um, who owns the property and who you should be contracting with. From the farm side of things, um, again, it depends. If you're operating as a sole proprietorship, you're probably going to be contracting in your own name. If
Sure.
you are operating under a business entity, you're going to want to be operating under that entity. So it really depends. Every situation's a little bit different. That's actually
Absolutely.
probably a good reminder. I could talk about this for hours, so maybe we'll try to keep ourselves moving forward and we can talk about what that looks like with different signers. But
Okay.
keep in mind, those written leases, I know you hear all of us attorneys harp on them, but they're really important for clarity and for ensuring that you continue to have access to that facility and know how the relationship is going to work. When we are looking at a written lease, we don't add a whole lot to the requirements. So we talked about needing those beginning and end dates, a rental rate, a description of the property, and now we need the agreement of both parties still. We add the signatures. So we want to actually have those names in there and have the signatures. So how do we actually figure out who should be signing our leases? The first step, in my opinion, if you are the tenant to be or the farmer, is finding out who the owner of that property is. And this can change. So you might have an owner who you think is the owner. Maybe it's the neighbor who's been living there for 20 years and you're going to rent the facility from them. But you may not always know how they own the actual property. So I thought we would pick on PDP a little bit and pick on your office. And so I Googled, where does PDP have their office? And if you're watching, you'll see in the upper right-hand corner here, Google told me that your address is 820 North Main Street, Juneau, Wisconsin.
Correct.
So I happen to know that Juneau is in Dodge County, Wisconsin.
Mm-hmm.
And in Wisconsin and many other states, property tax records are usually public. So my little trick for this is that I will find the county where the property is located, and I'll just go to Google and search, Dodge County property tax records. In Dodge County, they use a program called Ascent, again, publicly available on the internet. So I went into their land information search tool for their property tax records, down to property address, and I typed in 820 Main. So I didn't type in the whole thing because I wasn't sure exactly how it would show up in their system. But 820 Main got me to 820 North Main Street, Juneau. And on that page, then it started to tell me about who the current billing address for property taxes was. I've blocked that out if you can see it here, just for some privacy for your landlord there. But the name that was on there was an LLC. Well, now I know that if I'm PDP signing a lease with that landlord, it should be under the LLC's name because that's the owner of record. Sometimes that billing address is a little different than the owner name. So we do always want to keep an eye on that. But this actually turned out to be a great example. For those of you that are watching with us, what you're seeing down here under the owner's name is the current owner's name. Again, it was an LLC, but also a former owner. It was owned by a trust. And then before that, the former owners were what looks like maybe a husband and a wife in their individual names.
Yep.
So it's gone through a couple stages here. My guess, I can't say for sure because I don't know these folks, but my guess is what happened here is this husband and wife owned the property. They decided that they were going to do some estate planning, so they put it into a trust. And then at some point, they either decided to sell the property or it transferred through that trust to a beneficiary. So we saw a couple different ownership transitions. Sometimes when these ownership transitions are happening with someone who's not perhaps an experienced landlord, they may not think to tell their tenant. So for example, if I am renting, let's say instead of a heifer barn, I'm going to rent a freestall barn this time, and I'm going to rent it from my neighbor, who is a, say, 75-year-old woman who farmed many, many years ago with her husband, but they have been sort of out of the game for a bit now. And now that her husband is gone, she's looking for some extra income. She may at some point decide that she needs to do some estate planning. Maybe she's worried about ending up in a nursing home and her kids decide that she should go get a trust put into place. So she goes ahead and she puts that trust in place, and you keep paying her rent, none the wiser that technically the trust now owns the property. Technically, that would change who should be listed on the lease. It might even change how that rent check is getting written out. So all of that is to say, when we talk about who's going to be on that lease, it's important to know who the real owner is and if there are any transitions happening. Now, it probably feels a little uncomfortable if I go to my 70-year-old neighbor and say, hey, by the way, did you do any estate planning recently? Did you put it in a trust? Did you put it in an LLC? That's a little uncomfortable. Using the property tax records in many counties is one way to be able to see very quickly who owns this property currently and has it changed hands. It's not definitive. Actually, even on this site, it will tell you that ownership records may not reflect the most recent documents. You technically do have to go down to the Register of Deeds, but it does get caught up usually within a couple of weeks of a transaction happening. So they're usually pretty good. Gives you a little bit of assurance. Oh, and here was for folks who are viewing the slides, you'll just see a little bit bigger. There were a couple different owners there. So the same sort of conversation goes for our farms. If you are, again, operating perhaps with an entity, it's really important that you are contracting under the entity if you want to have limited liability apply. So I would work with your attorney or the folks who helped you set up that LLC or that corporation to know, first of all, if I have multiple entities, which entity should I be contracting under? And second of all, who are my authorized signers for that entity? Who should be on the signature line? When we talk about signatures, I also am going to point out that if we are just contracting as ourselves, so individuals, Kelly Wilford and Cassie, we may want to think about if we have all of the required signatures for that property. So not specifically required in all situations. It's very dependent on how the deed is structured. But you may want to consider if someone is married and if their spouse should be signing that lease as well. So for example, if a deed says and, Kelly Wilford and spouse, well, technically I should have both signatures. If it says or, I only need one. My rule of thumb is usually I try to get both just to help protect us, right? Keep in mind, again, different states are going to have slightly different rules and tools, but we want to make sure that we've got the right folks signing to make sure that the lease is enforceable.
Mm-hmm.
Wisconsin does have this handy tool on our farm management program website that helps you walk through a little bit of, is your lease enforceable, depending on if it's written or verbal and some of the terms that are in it. Again, it is not perfect. It is not a catch-all, but it's at least going to give you a start if you have a lease that you'd like to look at. So why do we care so much about those written leases? Let's talk a little bit about the risks of a verbal lease. When we have that verbal lease, that handshake agreement that goes longer than a year, it becomes what we call a periodic tenancy. And in Wisconsin, an agricultural periodic tenancy has a year-to-year term. So unless we agree in writing that it's going to be, week to week, month to month, if we just have a verbal deal, state law jumps in and says, hey, this is probably a year-to-year term because agriculture operates on that 1 year cycle. Different states have different rules, but if you're here in Wisconsin, we're probably operating on that year-to-year term. Why that matters is because Wisconsin law has specific requirements for ending the lease. If we're in that year-to-year verbal lease, either party can terminate the lease at the end of that year by providing written notice to the other party at least 90 days prior to the end of the term. Now, there are specific rules about how it has to be delivered. I'll just mention mailing, for example, typically counts. Personal delivery, handing them that letter typically counts. There's a couple others. Consult with your attorney if you're in that situation. But what does 90 days prior to the end of the term mean? And why does it matter? Like, what are you talking about, Kelly, when you say 90 days to the end of the term? They can just tell me get out? Sort of. Yeah. So if we're talking 90 days prior to the end of the term, let's look at what some different lease terms can look like. So a lot of, I'll say, crop leases tend to operate on a January 1 to December 31 term, a year, right? Mm-hmm. If that's my verbal lease agreement, January 1 to December 31, either party, either the landlord can send me a letter and say, hey, Kelly, get out. Or I can send my landlord a letter and say, hey, I think I'm done with this. Thanks so much for your time. but I have to do it at least 90 days before the end of the term. So if that's a January 1 to December 31, then we're looking at about October 2nd that I have to send that, they have to have that written notice by in order to terminate. If I don't get notice till, say, November 1, theoretically, I can fight and lock them up for another year because they didn't terminate in time. Now, this is especially important when we talk about farm land, because if we think about this calendar date, right, we've done a lot of work by the time we hit October 2nd. Think about if we've got winter wheat planted, we've got some fall tillage done. Maybe we spent the fall putting some tile in, prepping for next year. There's a lot that could be done to all of a sudden get a notice that says, and by the way, you're not going to have this next year. But alternatively, we don't always operate on a calendar year. So maybe your lease started in May 1 through April 30th. Well, now we're talking January 30th, assuming we don't have a leap year, for our termination notice. How much more do we have done? We probably have inputs ordered and paid for. We've got a crop rotation planned. That's a pretty, in my opinion, it's not research based, that's a pretty scary time to say, oh, and by the way, you're not going to have access to this anymore. Now, if we talk about livestock facilities, maybe this changes a little bit, right? Our 90 days still applies. And so you do want to know if I've got this verbal handshake deal, because again, this is the only thing it applies to, those verbal handshake deals. When did we start? Let's say I've been renting that heifer facility from you for the last 3, 4, 5 years, Cassie. Do I remember if we started March 1st or June 1st? Maybe. What if I've been renting it from you for 15 years? That gets a little bit harder to remember. That's where, again, if we can get it in writing, it's really helpful to have that documentation. And if we don't get it in writing, try to document it in your own notes anyway. Maybe it's a photo as you're moving animals in. Maybe it's a note in your farm records for the year. Try to keep in mind, when did that lease term start? Because it sets some guidelines over when it could potentially end. And as we talk about 90-day notice for farm buildings or for livestock facilities, I would ask yourself some of these big questions. Is 90 days notice going to be enough time to find a new location if we have to move animals? When does that 90 days fall? Again, picking on our big weather event here, are you running the risk of trying to move those animals in the middle of a Wisconsin winter? Are you running the risk of trying to move everything out of a machine shed in the middle of harvest? And again, that question we just talked about, do you remember when your lease started? Now, if anyone on here is thinking about, gosh, I don't remember when my lease did start. We've been doing this for 20 years. A really simple way to address this is to just have a conversation with your landlord. Remember, they're people too. And so that means you might sit down with them. Let's say you're taking the rent check in, you're dropping it off, popping into the kitchen, handing it off. You might say, hey, do you have 10 minutes? It would be great to catch up. Do you remember how long we've been doing this? Maybe I'm thinking about trying to do some farm succession planning. Gosh, I'd really like to make sure I know what to tell my next generation so that they make sure you keep getting your check and that we know when it applies to. I've seen a lot of older generations sit down together and say, look, neither one of us is getting any younger. I want to make sure that your kids have certainty and so do mine. It doesn't have to be a scary conversation or a big, aggressive negotiation. A lot of the times these are just conversations that we're having and then trying to document that we're both on the same page.
People are fun, Kelly.
They sure are, Cassie. They sure are. And it can be intimidating, right? I have the benefit of a law degree and lots of years studying this. I know that when we talk about all of this information, it can be a little bit overwhelming. So I really encourage folks, try to break it down into chunks. The first question you're going to ask yourself, do I have those bare minimum requirements? Do I know the beginning and ending date of my term? Do I know my rental rate, my property, And then do I have even just that bare minimum in writing or some way to show that we know when the term runs?
Question
Recognize
I
that
have
if you've
for you.
got,
Oh, sorry.
go
Finish
ahead,
your,
no.
then I have a question.
Yeah, I was just gonna say, go ahead and document those as much as you can, but
Mhm.
don't be afraid to have a huge, just a small conversation about it. It doesn't have to be a huge negotiation.
So my follow-up question, related or unrelated, in the idea or the event of termination, I understand like the 90-day cutoff and or like if you have the written version, this is the end date. How would you handle instances like feed storage? You've been there for X amount of time. I mean, some of these things are harder to move. Is that again a people thing? Is that like cut and dry if it's in writing? How do you handle instances like that?
Great question. It is usually pretty cut and dry if it's in writing,
Mhm.
right? And even if it's not in writing, we're still going to follow those 90-day termination provisions.
Mhm.
So feed storage can absolutely become a larger discussion. Um, what really comes to mind for me as we talk about that is it becomes a question of leverage and of people, of relationships. So let's say that the landlord decides they want to be done leasing that facility, but you know that you've got way more feed that you need to move and aren't quite sure maybe even where it's going yet, than the time that you have available.
Right.
That's going to be a situation where you want to confirm, first of all, did they get their notice deadline right? Are you actually truly out on that date? And then start those conversations around, look, I have to find somewhere to go with it. I'm willing to work with you. I'm not trying to be difficult, but what can you do to work with me here to help me find that time? Doesn't always mean that they're going to, but we want to try, right? I don't know if we'll have time to get to it, but when I talk about leasing, I often talk about a couple tenets behind what we call principled negotiation. It's a negotiation strategy out of Harvard's negotiation project. And the big idea behind it is really focusing on shared goals and shared values. So instead of, Cassie, you and I fighting over how we're going to get something done, we try to focus first on where are the places that we agree. So maybe
Mhm.
you terminate my lease for the heifer barn. And let's say there was some feed storage there too, right? I don't know why, but we're going to put it there. Um, and so you decide, you say, Kelly, I really need these back. I need you to get out by, the end of the year. Now, if we're having that conversation in March and the end of the year is December 31st, I've got 9 months to start making some decisions. It may not be super fair for me to say, hey, I don't think I can do that, right? That might upset you when you say, Kelly, I've given you 8 or 9 months, find a
Mhm.
way. Um, Alternatively, if you come to me on September 29th and say, Kelly, I need you to be out at the end of the year, well, I really am in a position where I don't have a lot of other options, right? I've got a pretty quick turnaround to try to do something here. And I'm probably making that ask to say, Cassie, I fully respect that, you're planning to do something different here, and that's okay. But I'm going to need a little bit more time. And we might have to have a conversation about how much more time that is. Is it for both the heifer barn and let's say a feed pad? Or is it just for one or the other, right? Maybe I can have the heifers out, but I'm going to need a little time on that feed pad to get things rearranged. Um, and what we might find by having that conversation is you might say, oh, that's fine. I really just needed the heifer barn back. We can work through the other issue. Um, but if we can focus on, look, we're both trying to provide for our families here, we're trying to do what's best, but we have to be realistic. Having it as a conversation and trying to take as much emotion out of it as we can be really, really productive. So as you talk about ending a lease, we talked a little bit about the 90 days, and you said spot on for those written leases. Keep in mind that if you have a written lease, that written lease is going to end when the term expires. So if our lease term was January 1, 2025 to December 31, 2027, that lease ends December 31, 2027. You don't have to send me a written notice. we can just be done. I do try to encourage our landlords and our tenants to communicate as they're approaching that date to either say, hey, it's been great working with you, or maybe it hasn't. But either way, I'm going to move on December 31st, 2027, just so you know. Or, hey, just a reminder, our lease ends December 31, 2027. I'd really like to continue. Can we start talking about an extension or some changes to the lease that we have so we can move forward? So there's that reminder. Sometimes we might want a courtesy reminder whether we want to renew or not. The more we can have that open line of communication, the healthier it often is. I will throw out here what happens if one side, if the tenant won't leave or won't pay, or the landlord has missed the notice date but is insisting the lease is going to end. There's a couple places that we might end up. And I'm actually gonna, if you're looking on the screen, I'm gonna talk about them from the bottom to the top, sort of in order of severity, perhaps. So when we run into these disagreements, whether it is over termination or whether it's over some other issue of the lease, one option that our Wisconsin farmers have is to work with our Wisconsin Department of Ag, Trade, and Consumer Protection. The Farm Center runs our USDA mediation program, which is a free mediation program for farmers. Both sides do have to agree. So sometimes we might write this into the lease up front that our landlord is agreeing to participate in mediation. It's, again, probably going to be cheaper since it's free. They're not going to make a binding decision, but they'll provide you with a neutral third party who's going to help you talk through those difficult conversations and try to reach agreement. If we can't come to an agreement, we might be looking at small claims court or a civil action in regular civil court. Each of those are going to be a lawsuit. It's going to be legal action where one party is suing another. Small claims court is typically a lot of folks will handle it pro se, representing themselves, but it's usually for eviction or for claims that are less than $10,000. If we're getting above that, we're going to end up probably in civil court, which can be a little bit more expensive, and you'll probably want an attorney to guide you through those processes. One of the things I want to really talk about here, these are sort of the big what ifs. The what ifs, are we going to end up in litigation? That doesn't mean we should always jump there right away or that we have to jump there right away. There might be negotiations between the parties ahead of time, whether that's with legal counsel or without, to try to resolve some of those differences. You do want to keep in mind what the relationship with that party looks like. So we talk about the 90-day notice on the verbal leases. And I've certainly seen farms that say, they were a week or 2 weeks or a month late. I'm going to stick it to them and I'm going to get my extra year out of it. And that's a legal right? Like that's the way the law works. However, I can almost guarantee to you won't work with that landlord again. They're not going to be happy about it. And so you do want to think about the relationships and how they're going to be impacted as well. Will that build a reputation for you in the community as well that could make it difficult? Versus, is it really a situation where you are so invested that you simply can't afford to lose that property at that point in time? I would really encourage you, if it is a property that is that vital to your operation, try to get a written lease in place so that you know exactly when the lease is going to terminate and how those interactions are going to play out. If you are working on whether it's a written lease or a verbal lease, don't hesitate. For some of our more tech savvy folks, put reminders in your phone or your internet calendar or on your written calendar that say, okay, here's a date when a lease is ending. I want it to notify me 2 weeks before so that I can go have a conversation with the landlord about what's going to be next. 2 weeks might be a little short, maybe go 2 months. But have those dates listed somewhere or triggered to remind you somewhere so that you can actually plan for those risks. We've only got, I think, about 5 minutes left, right, Cassie? This is one of those conversations we can have for hours. So I think what I'm going to do with the next couple minutes is just highlight some resources for you. We talked a little bit about facility management and all of those conversations that are likely going to be contained in a lease beyond just the bare minimum. I'm going to share, and I think you'll have linked in the Dairy Signal portal or website, access to some various resources, including a sample farm building and livestock lease. I was going to flip over to it and walk through it, but I think I'll just sort of read through it a little bit here instead. Specifically, there are terms about how the property is going to be managed. So there's a section called Operation and Maintenance of Property that starts on page 2, and I think goes through page 4. And it talks about, for example, uses of the property. So what is the tenant or the farmer actually allowed to do on that property? Let's say they're renting out a machine shed. Can they decide that they're going to turn it into a facility for animals and put animals in there? Or is it limited to using it just for storage? Are we widely opening it up that it's for agricultural purposes, or is it what we would call exclusive use, meaning you can use it for whatever you want? It talks about general maintenance. So typically day-to-day maintenance, wear and tear during the lease is going to end up being the farmer or the tenant's responsibility. Things like those basic repairs. You're probably going to be asked to have some insurance. You may also be asked to list the landlord as an additional insured, so that they get paid out if something happens on the property, or so that they're equally protected.
So Kelly,
Again, you're gonna, yeah.
what happens when you want to make, I understand like general maintenance and that in my mind that makes sense. So what happens if you want to make like a major upgrade to a facility? You don't own it, but you want to do something. And then like, do you cost share? Like, is it a 50-50 split? Do you decide who should be investing in that? And then say you guys end up parting ways either next year or years from now. Do you have the right to pull that out and take whatever upgrade that was with you? How do you handle things like that?
You're always going to want to negotiate them up front, Cassie. So if they're not in your original lease about how you're going to handle those items, and what I as an attorney would typically call those would be like capital improvements or improvements. Those would be, big property fixtures that we've added. So let's say we're putting a different parlor in or parlor system in. We are adding, we're extending a machine shed. We are putting a well in, right? Those big sort of really tangible additions or improvements to the property. If they're not addressed in our initial lease, right? We maybe haven't thought of them up front. Or we didn't know that we wanted to do them going into the lease. It might be an amendment that we want to add to the lease, or a separate agreement that we negotiate. You also can try to negotiate them up front. The challenge often is, things that we know about versus things that we don't, right? So structural issues, for example, are typically going to end up being the property owner's responsibility. However, if we are adding something that is good for us as the operator in that facility, the building owner may not be as eager to pay for it as what we might be, right? And so we're going to want to negotiate, are we adding something, first of all, that we're going to take out with us? If we can put it in and take it out, then maybe we're paying for it up front and we're just getting approval if we're making some modifications to that facility. Alternatively, if we're making an upgrade that we can't just take out and take with us, we might want to think about some cost share. That could be a cost share of the improvement up front. That could be a change in the rental rate based on what we're paying for up front. Alternatively, you might have a landlord that says, look, you're the one that wants it. I don't really care, so you pay for it. It is unfortunately just one of the realities of leasing, that we sometimes have needs or interests that are not necessarily what the landowner would do on their own. we won't have time to talk about it, I don't think, in detail when we talk about rental rates, but there are going to be a variety of resources available for you, different worksheets for estimating some of those costs, some of the different surveys and rental rate research that you can look to see what are others paying or how might you calculate it. But one of the kind of core tenets of those estimates is usually that the tenant is going to pay operating costs. So anything that you do that's adding additional cost to what the property owner would have, pretty standard that you as a tenant are going to be paying for those. However, we get into a little bit of that gray area with improvements and with our fixed costs, right? Because certainly a property owner who doesn't have a lot of demand for their facility, right? They're not having a ton of folks come up and bid out that barn. Well, they might say, a little bit of rent up front is better than nothing. Um, but there's going to be a balance with those capital improvements. Do they really want to put more money into it? And is the rent that they're getting back for money that they put in really worth it? What's that return on investment?
Mhm.
Uh, these are tough because our facilities, depending on what area you're in, may have different levels of demand. They may have different levels of specialization of what each farm is looking for, and of what the age of that facility is. So it's really, really very dependent on the situation. But if we're looking at those big improvements, it's all going to be about negotiation and trying to figure out what's fair. And I always say what's fair is usually what both parties can live with.
Mhm.
Um,
Absolutely. So
so a
then,
lot to take in there.
and maybe I'm opening a whole new can of worms, and you're like, this is a topic for another day. Both are fair statements here. If you go from a lease, working with a neighbor or whomever, and then you want to branch into like maybe it's part of your succession plan and maybe theirs to do like a lease to own. Um, how does that, or even like have that right to refusal or first offer, like that discussion, how do you approach it? When is it appropriate? How can it be done?
Yeah, great question. So, when and how you approach it is always going to be dependent on that relationship, right? And being respectful of the other party's wants and needs and where they're at. There may be times where they're more open to the idea than others. And so you may start to mention it and sort of gauge interest in the idea before you launch in full force. Other folks may be more comfortable saying, I'm just going to lay out my entire offer and hopefully they like it. It really depends on the individual in that situation. But as we talk about, I'll say like a rent to own or a right of first offer, right of first refusal, those
Mhm.
can be great to negotiate into the lease itself if the party is open to it. So, let's say that you have been leasing a facility for 10 years, and maybe the current landlord you think would be pretty open to selling it to you, but perhaps they are waiting to get a step up in basis upon death, and then they'd be open to that transaction happening. Well, that's awful hard if they're not here anymore, right? And
Mhm.
so sometimes having that right of first offer drafted into our lease, we might pay a little bit for it up front, right? We might have to put some extra dollars in to get that right of first offer or right of first refusal.
Mhm.
Um, but we can get that written in. We can do it in the lease. We can do it in a separate document. The big one with rights of first offer or rights of first refusal, two different things. But talk to your attorney about which one's right for your situation. But with those, we do want to make sure that they get recorded down at the county register of deeds, because they do need to be part of that public record in order to be enforceable. If you have a written lease, technically you also can record that, and that's going to help ensure enforceability too, in case there's a sale of that land or of that building. It's not strictly required, but it is a step that can be helpful. With our right of first refusal and right of first offer, though, it becomes a requirement. You're going to want that recorded in order to be able to enforce it. You did talk a little bit about rent to own as well. As far as the interest in that, again, you're going to have to gauge it on a specific landowner interest level. Um, and try to estimate when you think you are most interested in pursuing that. There's probably going to be a little extra paperwork. You're probably looking at a land contract as opposed to just your standard lease, which there's a whole host of considerations for that too. But just know if you're thinking about farm succession, that certainly can be an option to negotiate in general, all of these topics really stem back to that communication with your landlord, right? Having those open conversations and really thinking of them as a person, right? What is it that they're interested in? What are they trying to accomplish? What does their family look like? What do you know about their financial situation, their health? And I know that sounds a little bit greasy, right? Like a little like, oh, we're really digging into them. But if you can help think about what is it that they need and then try to offer a solution that meets your goals and their needs, you're usually that much closer to actually getting a yes. But they like to be treated like people too and know what's going on with their property and their facilities. So even that 10-minute conversation once a year can really make a big impact if you can take the time to do it.
Absolutely. The one thing that stuck with me from our attorney just working through various things, he's like, more times than not, it's a people issue or conversation than it is a legal issue or conversation.
It really
People,
is.
we are fun.
It really is. Yeah. I
Mhm.
mean, and that's where the legal part can be so helpful
Mhm.
because it forces us to talk through those conversations early and address those issues. But people change, situations change, and so often things come up that we never expected. And in those situations, we're really focusing on relationships and trying to navigate through those needs.
Absolutely. Well, Kelly, as we round out today's discussion, what did we leave out there? Like, if you had one last thing that you either want to plug in or if you want to give our listeners one key takeaway, I'll even let you bridge into two if you'd like. Key takeaway for today's discussion, what would you want folks to walk with?
The big takeaways for me, number one, really understand that it's okay if you have a verbal lease, but know what your risk is. Know
Mhm.
when it's possible that it could be terminated and know what your backup plan is going to be. Um, there are a lot of risks that could come up, a lot of disagreements, um, but at least know when it's possible someone could sort of pull the rug out from underneath you and you have to be ready to pivot. The other piece that I would talk about as a takeaway is just communicate, communicate, communicate. And I know it feels like that is all we talk about sometimes is how to talk to each other. But it's so important to tell that story. And if you're not a talker, if you're not super comfortable, perhaps swinging by for a 10-minute chat or asking the landlord to go out to coffee or lunch, it's okay to write them a letter too, right? Write them a letter, send them a couple photos, help them understand how they fit into your operation.
Mhm.
I know it takes an extra 10 or 15 minutes on your side or an hour, right? Maybe it takes a little longer to put some of those things together, but that relationship can really pay dividends if they're feeling like they can have an open conversation with you about what's happening on their property and feel like you really are a partner in managing it together.
Absolutely. Well, Kelly, thank you for your time today. Thank you for your insights and your expertise. We greatly value not only the partnership that we have with you and your team, but just again, all of the points that you brought forward today. So again, thank you. Thank you for your time here. And
Thank
again,
you. And I know we didn't get to all of the resources. I know you'll have a bunch of them linked. I'm just going to flip through so that if folks are looking for my contact for information, either to talk about any of these topics, it's available on the screen here.
thank you. Thank you. That helps. That helps.
Thank you.
We're all about helping people get connected, but if it's on the screen, just one faster way to do it. And with that being said, again, everyone, thank you for joining today's episode of the Dairy Signal. We have more great topics coming down the pike here, so don't hesitate to join in. We're live every Tuesday and Thursday. Otherwise, listen in at your convenience. Use that search bar, go back topics as far as you want. You can search by presenter, you can search by topic, or you can just cruise. I mean, it's really a tool for you to utilize. I know a couple of points that were brought up were negotiations. If you want to search and learn and lean into more on the conversation or the people side of that, we've worked with a great resource, Linda Swindling, in the past, and she's been on the Dairy Signal as well. So you can dive in and listen to a few of her episodes too, as well as obviously countless others. I do also want to draw everyone's attention to our website, pdpw.org. If you haven't already found it, there's a lot of great programs coming down the pike that will be in person. Most of them here in Wisconsin, but please don't be shy. They're tools for you to leverage. Your time is invaluable. So make sure it's a conversation, it's a topic that you want and you're interested in. So always check out what's coming down, and it can be useful for you at the PDPW website. Without further ado, again, thank you for tuning in to today's Dairy Signal, and we hope to have you tune in and listen in again. Take care, everyone.